So good evening, everyone. Welcome back to our webinar series. We are continuing the previous session that we had this last Sunday, and we are talking about the changes in liquidation and voluntary liquidation today. And yeah, we will take it forward now.
Thank you, Ankit, and namaste. Good evening to all the participants. We are very happy that in the last Sunday webinar, the participation was very high, and we are expecting, since it's a follow-on of the same, and the lot of changes have been notified now in the liquidation process regulations, and there are a lot of questions which comes into the minds. My partners have also raised a lot of questions. My employees have also raised a lot of questions. So that's all we are trying to discuss today. We will also take questions from all of you, and whatever apprehension that you have, please mention in the question and answer tab below this Zoom. So without wasting much of the time, let's start the webinar with the liquidation process regulations notified on 16th of September 2022. So these regulations, I would also be shuffling from the text which we have, and the text is very clear. The text is very clear that it is effective from the date of their publication in the official gazette. This is important, and we definitely will discuss on this why this is important. So first of all, a few amendments which are significant, but primarily
so there is a latest PPT that has come to your inbox. Maybe you'll have to share that one.
So I should stop sharing that, and maybe that I will do the, I hope now it is visible.
Very much. You can just make it full screen.
So the first amendment is regarding Regulation 2B, and as I said that this is something where the IBBI thought, and also based on various feedback, that this compromise and arrangement scheme under Section 230 of the Companies Act, which is consuming a lot of time, and it actually adds to a lot of litigation. And this is also one of the reasons that the liquidation processes are not being closed as per the timeline. So therefore, this originally it was proposed, and now they finally have made an amendment in Regulation 2B, provided further, where the recommendation to explore proposal of compromise or arrangement has been made by the COC under Regulation 39BA of CIRP regulations. The liquidator shall file the proposal within 30 days of the order of the liquidation. Now, first they made an amendment in a regulation, CIRP regulations, and they inserted 39BA regulations, where they empowered committee of creditors that in case the committee of creditors would like to explore the possibilities of any scheme under Section 230 of the Companies Act, then they should decide now. And then it is also made very clear that since the committee of creditors have decided, secondly, the amendment has been made in the CIRP regulations that the RP can continue to have COC meetings during the period when a resolution plan approval application has been filed before adjudicating authority, or an application to liquidate the company has been filed before the adjudicating authority. From that date to the final order of the adjudicating authority, maybe for approval of resolution plan, or maybe the order to liquidate the company. During that period, the COC meetings can also happen, and all those matters can be discussed, which does not impact resolution plan. So therefore, like, let us see the three things together. One, the CIRP amendment, where the regulation 39BA was inserted, where it was empowered to COC that in case the COC thinks that any scheme under section 230 can be explored, that should be decided now. And in case it is decided, then the application which is filed by the liquidator which is filed by the RP to liquidate the company, in that application this intention of the COC should also be mentioned. Then the second amendment is that during this period, when the application is filed to liquidate the company, the COC is empowered to take decisions, all those decisions which does not impact resolution plan. So when the application is to liquidate the company, so all decisions can be taken because there is no resolution plan. Now the third is that regulation 2B, which says that the liquidator shall file the proposal within 30 days of the order of the liquidation. Now, see, what was the regulation before this amendment? First of all, it was for 90 days. Then the 90 days period would not be considered into the liquidation period. It would be over and above that, because in case it is 1 year liquidation period, so in case of any scheme, the scheme period would be increased to 230, increased to by 90 days, and then it was related to various costs. However, the main issue in this particular amendment is that within 1 month, when we say, that means that the scheme can be received by the RP under section 230 of the Companies Act immediately after an application to liquidate the company has been filed. Next, the creditors can have meetings and they can consider that scheme under section 230. The creditors can also give their approval after taking internal approvals from their authorities. So if the scheme is approved, the meetings of the committee of creditors happened, and the approved scheme will be submitted by the liquidator to the adjudicating authority within 30 days of the order. That means, if you see the flow of the changes, first change, the COC is empowered to have the meetings and take decisions during this period. Second amendment is that the COC has been empowered to consider if any scheme under section 230 can be explored, and new regulation 39BA was inserted. And the third is that now, since everything has been done during that period, so the liquidator will get only 1 month to submit the scheme to adjudicating authority. That means that with this amendment, the lot of time has been saved. But my understanding is that in case any scheme is received after 30 days from the commencement of the liquidation, then the liquidator is not supposed to consider that. And the stakeholders consultation committee also would not consider that. Of course, that is a separate matter, that in case the NCLT allows it. However, the liquidator would not consider any scheme under section 230 if it is submitted after 30 days from the liquidation commencement date. So Ankit, any opinion that you have? I think it's clarified very clearly.
I think that's the interpretation, that because it has two-sided. One, the liquidator has been made liable to make sure that it is filed on time. Secondly, 30 days is further clarified. So I think that's it.
Now coming to the regulation 4. Regulation 4 is very important for all the insolvency professionals, which it talks about the fee of the liquidator. Now they after the subregulation 1, regulation 1A has been inserted. When we talk about regulation A, in case we talk about the regulation 4. Now the regulation 4 is
Just one back, one previous you will get it. It was the liquidation fee.
So regulation 4, it says liquidator's fee. And in case we insert regulation 1A here, and then we come to know that where no fee has been fixed under sub-regulation 1, the consultation committee may fix the fee of the liquidator in its first meeting. So that means that it is not really important that the COC decides about the fee. The COC can definitely continue with the resolution process, and in case it is not, and many cases the COC doesn't get an opportunity to talk about the fee, and later on they feel that this is a wrong decision that they have taken, that they should have discussed. But now the stakeholders consultation committee has the power to fix the fee of the liquidator in case it is not decided by the COC as per regulation 39 capital D of the CIRP regulations. So this
So the consultation committee is the same as the COC. There is no change in the structure.
No, in the first meeting, it is the same as the COC in the first meeting, because the first meeting will happen within 7 days.
So
and
that's
we are
where, so that's where the first meeting will happen. So whether the liquidator fee is discussed in this during the COC or during the first meeting of the consultation committee, the only change in between the two processes is that if it is discussed in the first meeting of the liquidation process, then the whole change in liquidator, in case the fee is not acceptable, will maybe it will involve a process. But in case the liquidator is not agreeable or is not agreeing to a fee proposed by COC, the COC can propose a change in the liquidator in the COC meeting itself, in the last COC meeting itself.
Yes, but then finally, what is recommended? Number one, that the COC should decide the fee of the liquidator under regulation 39 capital D of the IRP regulations. The liquidators also should try to get the fee fixed for any kind of dispute later on. Because see, like once a liquidator is appointed, then the COC would have to give reasons why the liquidator is being removed. And that actually will go to NCLT, and that can be a little long drawn litigation. Because see, then the COC will talk about either some kind of inefficiencies or some kind of charges or some kind of fee issues. All these things can be disputed by the appointed liquidator. So my suggestion to all the committee of creditors is that it should be fixed. In case it is not agreeable, then they can even propose change of the liquidator. That's what is my understanding. And I think this is what about this is not very big. And then we can move on to regulation 12 and sub-regulation 2, and it has been this proviso this clause C has been inserted. Now what this clause C says, it is the regulation 12 primarily. Let me first of all tell you that the regulation 12 is all about the publication of notice. So when we talk about publication, public announcement, it is the public announcement that we have to make. And then the public announcement also has A and B, and then there is a C which is inserted. Provide that where a stakeholder does not submit its claim during the liquidation process, the claim submitted by such a stakeholder and duly collated by the IRP or the RP, as the case may be during the CIRP, shall be deemed to be submitted under section 38. Now, there are 2-3 questions. One, and this is very clear, that in case the claims are not submitted, the claims can be admitted or claims can be taken from the CIRP process. Now, there are questions which has been raised to me. Number one, what if a person is not interested in submission of the claim? He understands that the company doesn't have any assets, so he is not interested in submission of the claim. So in case we admit his claim, then would he have right to withdraw? According to my understanding, the withdrawal of claim is permitted within 15 days. So in case the liquidator admits the same claim and the claimant or the creditor is not interested to participate into the process because he is well aware that there is no possibility of any recovery, then I think he still has the right to withdraw. Now,
but in what event will the person who is filing a claim or whose claim has been accepted by the liquidator based on the CRP claim would want to withdraw the claim, because there is no it is expected that they will have to bear some kind of cost. That's the reason that they will like to withdraw their claim.
Yes, because see, there are regulation which says that the estimated liquidation cost will have to be contributed by the financial institutions. If we see this regulation 4, regulation 2, in fact, I would just for this understanding why they are saying so, because this regulation 2A is contribution to the liquidation cost. And this is obligatory on financial institutions and non-financial institutions. So the financial institutions will contribute the estimated liquidation cost, and then even I can even say withdrawal of the so it is there in the in the Act. I will just see the Act. In the Act, it is written withdrawal. Withdrawal of the application, and anyway, but then there is a let's not spend much time on this, but there is a regulation which allows the withdrawal, and that is only 15 days that it can be allowed. I can even see that if I can find in section 33 itself. सभी तो नहीं मिल रहा, but then we can say maybe it is in the
38.5. That's one of our participants have shared that section 38.5.
So consolidation of claim 38.5, a creditor may withdraw or vary his claim under this section within 14 days, because it was 14, I was finding 15, so it was not finding. So 38.5 says that the creditor can withdraw. So my understanding is there are two issues in this. In case the creditors want to withdraw, still he can withdraw even if it is collated by the liquidator based on the CIRP claims. Number two, he can still modify and he can file it a little later, and his modification can also be done in case he wants to change the claim. That also is possible. So I think the objective of this amendment is, to my understanding, when a person can file the claim in CIRP and he is not filing during liquidation, I'm not really very sure that it has on what basis this has been done. But anyway, it is an additional obligation on the liquidator, that the liquidator will look into all the claims, and liquidator will then compare with the claims received by liquidator during liquidation process, and then only the liquidator can constitute stakeholders consultation committee. Any question on this issue, Ankit, or we can even discuss?
We should move forward. I think this is pretty clear that this is how it is.
Clear.
Yeah, we have
then
a lot
is the
to cover.
Process email ID, the liquidator shall operate the process email account handed over to him by the resolution professional in accordance with the regulation 4C of the CIRP regulations, and in the event of his replacement, the credentials of such email ID shall be handed over to the new liquidator. So what
So the same
which is
ID
very
will
clear.
continue throughout the process. So rather than
Yes.
now saying xyz.cirp, we should simply say xyz maybe .ibc or xyz@gmail.com, whatever. That would work better.
Yes.
Because maybe the CRP ID will continue to be used for liquidation also. There is a possibility.
So the same ID, first of all, the regulation 4 capital C was inserted in the CIRP regulations, where the process email account has to be handed over from IRP to RP, and from RP to replaced RP, and now from the liquidator to replaced liquidator, or from the RP to liquidator. So the same email ID will have to continue. So there was a tradition in the market to add CIRP or liquidation in the word. So I think now the only thing that the name of the company, and then we can add even IBC, and then the Gmail. That's or any other. So this is what is required. So I think this is all very clear. Public announcement, because and this. Now, in case we see this regulation 15, which is regarding the progress report, and the earlier wording in this regulation was that the regulation, it was very clear that the adjudicating authority will get this progress reports. It is written here that the progress report to adjudicating authority. And the amendment is that the progress report in the format stipulated by the board to the adjudicating authority and board. So the two things have been added. One, that there will be a format stipulated by IBBI. Secondly, that the progress report would be submitted to adjudicating authority and the board, means IBBI. So this is the only amendment. And there is another very important amendment, and that is in the subregulation 4. And in case we see subregulation 4, it is clear that the progress report shall enclose a statement indicating any material change is in expected realization of any property proposed to be sold, along with the basis of such change. And then there is a proviso that this statement shall not be accessible to any person during the course of liquidation unless permitted by the adjudicating authority. So this proviso has been removed. Now, what is the objective? The objective is that if there is a statement showing material change in the expected realization of any property proposed to be sold along with the buyers, I think let everyone know, because why should this statement be very, very confidential? Let all the stakeholders know that there was an expected realization, then there is a change in the expected realization. If there is a decline, then the liquidator is answerable. So this proviso has been omitted. So this is again very clear. Now, coming to the regulation 30 regarding verification of claim. So it is a consequential amendment to the regulation 12, where the liquidator is now under obligation to see the claims admitted during CIRP period. And now the liquidator is also made responsible to verify those claims which were admitted during CIRP and not submitted during the liquidation process. That also has to be done within 30 days from the last date for receipt of claims during liquidation process. So this is also consequential to that 30 days is also the same period as we have been given for fresh claims. And within the same 30 days, we have to even re-verify the claims submitted during CIRP, but not submitted during liquidation process. So Ankit, now we are moving on to a very, very important amendment, that is Stakeholders Consultation Committee. Before we do that, I think we would like to take any question which is other than the Stakeholders Consultation Committee. Then in case there are, let us see.
Not really, not many questions. So the questions are already on the SCC only. So I think we should just.
So I think
take it forward.
we'll just move on the SCC. The first of all, very important that we should also see the existing regulation 31. 31A is the regulation for constitution of consultation committee. So the very first sub-regulation 1 has been substituted, and now the liquidator shall constitute a consultation committee comprising of all creditors. So the very first word that we have to focus is all creditors. Now, when it is all creditors and it is not stakeholders, earlier it was based on the stakeholders, list based on the stakeholders. Now the based on the stakeholders is no more there, comprising of all creditors of the corporate debtor within 60 days from the liquidation commencement date, based on the list of stakeholders prepared under Regulation 31 to advise him on the matters. Still, one is the word creditors, all creditors. That means all creditors means all secured creditors, unsecured creditors, financial creditors, operational creditors, workmen, employee, government authorities, shareholders. And the shareholders are not creditors, but then yes, they also have a place in the committee. So these are all creditors. So the consultation committee would comprise of all creditors. And the second is that still the role is only to advise him and advise on the matters relating to remuneration of the professionals appointed under Regulation 7. Sale under Regulation 32, including manner of sale, pre-bid qualification, reserve price, marketing strategy, and auction process. Fee of the liquidator. Valuation under Subregulation 2 of Regulation 35. The manner in which proceedings in respect of preferential transactions, undervalued transactions, extortionate credit transactions, or fraudulent or wrongful trading, if any, shall be pursued after closure of liquidation proceedings, and the manner in which the proceeds, if any, from these proceedings shall be distributed. So this is the first regulation, sub-regulation 1 to Regulation 31, capital A, and these are the responsibilities of the stakeholder consultation committee to advise the liquidator, or responsibility of the liquidator to take advice from the stakeholders, from the creditors. Now, after Regulation 1, the following shall be inserted. Now, after Regulation, the 1A actually has been added. Another regulation which has been added is 1A, which says that the Committee of Credit under Section 21 shall function as the consultation committee with same voting right till constitution of the consultation committee under Sub-Regulation 1. Now, the Sub-Regulation 1, it says that it has to be constituted within 60 days. Now, first of all, the 60 days, till 60 days, the COC will continue. Till 60 days, the COC will continue. And once the SCC is constituted, then the new SCC will start giving advice. Otherwise, the COC will continue to give advice as the COC was giving or taking decision during CIR. Now, the next is the Sub-Regulation 2. Now, Sub-Regulation 2, in fact, has various, the composition part. All this is a composition part. We have seen one, and in fact, all this ABC, it was only AB, and you have seen this now 1, 2, 3, 4, 5, 6. There are now 6 things, and this scope of this SCC has also increased. And now let us see.
So coming back to Sub-Regulation 1, it still says list of stakeholders. It only adds all creditors, but it still refers to list of stakeholders as per Regulation 31.
Yeah.
So like were there any stakeholders in Regulation 31 who were not stakeholders earlier?
No, let us see the list of stakeholders. The list of stakeholders, the liquidator shall prepare a list of stakeholders category-wise on the basis of the proof of the claims. So the amount admitted, the liquidator shall file. So these are all based on the claims. The list of stakeholders are all claimants. All claimants.
So what has okay, it simply says comprising of all creditors of the corporate debtor.
Yes.
But it still refers to based on
no, but then there is a slight difference into this. When we see the regulations, there is a definition of stakeholders. And let us see the definition of stakeholders. I'm very clear that there is some important to this. Find stakeholders. Now, the stakeholders definition is given in the CIRP regulations, and the regulation number is regulation 2(1), and then it is the K. Stakeholders definition say the means the stakeholders entitled to distribution of proceeds under section 53. Entitled to distribution of proceeds under section 53. So now what we are trying to understand is the first of all, the comprising of all creditors based on the list of stakeholders prepared under regulation 31 to advise him. Now the stakeholders are those persons who have some entitlement under section 53. And if there is a person who doesn't have any entitlement under section 53, he would not qualify as stakeholder. So he will not be appearing in the list of stakeholders. But I think slightly there is a confusion. But whenever we see this regulation 31 talks about all claims. And the list of stakeholders, in any case, they actually have a stake, and whether they would get some money or not, that is also not significant. But that means that the creditors and the stakeholders are almost same, and there is no difference.
I think so. I am getting the interpretation of the list of stakeholders. There is no change in the definition, but now the definition has been rather made smaller by saying that only the creditors will be part of this committee. If there is any stakeholder who is not a creditor, then he will not form part of this committee. The second interpretation that I have is that because you are now looking at claims made in the CIRP period to understand if somebody had made a claim. Now you're because you're also accepting his claim, which was filed in CIRP as it is, you're also making him a stakeholder because of that claim filed by him as a creditor. These are the two things that I am making out of it. Of course, there is a wide change in the scope of work of the SEC. That's a different issue.
Right. But then my understanding is that when we talk about creditors, the creditors would not include preference shareholders and the equity shareholders. So the stakeholders
might include that. Yeah.
The stakeholders will include that in case some companies have that kind of asset that even the shareholders are also getting some kind of dividend. Yeah. So this difference definitely would be there. Creditors would not include shareholders, may it be equity or preference, and the stakeholders would include this. So let's go ahead, and then we will try to understand the difference between creditor and stakeholders. Now, after this sub-regulation 2, the following shall be substituted. The voting share of a member of the consultation committee shall be in proportion to his admitted claim in the total admitted claim. That means there is no difference between the secured creditor, unsecured creditor. So in case there is a company where the secured creditor has a claim of 60 crore and the government department has a claim of 100 crore, then in that case, the government department will have more. Share. But then the question is, in case the stakeholders, the definition of stakeholder does not cover government department, because see, the liquidation value of the company suggests that the government department will not be getting any amount. Because see, again we say means stakeholders entitled to distribution. Now, entitled to distribution is something which is factual or a kind of theoretical. Theoretical, yes, but in case actual, then the liquidation value is very low, so the shareholders are not entitled to. But in any case, the 60 is the claim of the creditor, secured creditor, and 100 is the claim from the government department. So that means that the government department will rule the consultation committee, although as per section 53, they are not entitled to get any distribution. So I think this difference has to be very clearly understood, that whether they would be part of the consultation committee or not, in case they are not likely to get any amount from the distribution, because the very cleverly, the word all creditor has been used, and then the word stakeholder has been used. So we have to interpret the intent behind this. So I'm actually trying to say that in case the stakeholders are not likely to get any amount, then they would not be entitled to become part of the SCC.
But there is a practical issue in understanding and trying to understand if they will get something or not. So I think the eligibility to get something itself makes them part of the SCC, because nobody knows if the asset will sell for 100 rupees or 1,000 rupees.
No, if that was supposed to be done, then why under section 53 was supposed to be written?
Entitled
To any distribution of proceeds.
It's not likely to get distribution. It says entitled to distribution proceeds. So entitled to distribution proceeds under section 53 will be anyone who is going to get anything. It also perhaps includes the equity shareholders also, because they are also stakeholders, because they are also having an entitlement to distribution under section 53.
And I think we can further go ahead, and then we will understand. The voting share of the member shall be in proportion to his admitted claim in the total admitted claim. So the operational creditors will also have a voting share. The government department will also have a voting share. The workman and employee also have a voting share. Unsecured also have a voting share. So this is something which is the consultation committee voting share. Provided a secured creditor who has not relinquished his security interest shall not be part of the consultation committee. Very clear. Provided that the promoters, director, partners, or their representative may attend the meeting of consultation committee, but shall not have any right to vote, because see, there is no word like shareholder, because this is regarding promoter. So the shareholder will come further. They are entitled to attend the meeting, but they actually have no right to vote. Provided further that a financial creditor or his representative, if he is a related party to the corporate debtor, shall not have a voting right. This is like COC meeting. So this is also clear. Moving forward, for the sub-regulation 3, the following shall be substituted, namely, the liquidator may facilitate the stakeholders of each class, namely financial creditors in a class, workmen, employee, government departments, other operational creditors, shareholders, partners, to nominate their representative for participation in the consultation committee. So the committee would be made of creditors. I'm totally now confused. The committee would be made, let us again go back to the first sentence. It is written, the comprising of all the creditors of the corporate debtor within 60 days and based on the list of stakeholders. Now coming to this is, the liquidator may facilitate the stakeholders of a class of creditor in a, so then we actually have to facilitate them to choose their representative on the SCC, like the class of creditors like debenture holders, home buyers, or deposit holders, workman, employee, government department, another operational creditor, and shareholders, to nominate their representative for participation in the consultation committee.
So I'm saying so basically this is the AR provision. Wherever the numbers exceed the minimum numbers, there the liquidator is supposed to give them a representation, because
that only question is, in all cases, do we have to give the representations to operational creditor and also to shareholders and also to government departments, even if they are not entitled to any distribution under section 53? Even if they are not entitled to any distribution under section 53, because entitled to, I believe, based on liquidation value. Entitled to, I believe, based on the liquidation value. However, in this case,
let's see how it
progresses. In this case, the committee, there can be various situations where the actual people who would actually be entitled to the amount, they would be outpowered by those who actually would not be getting anything under section 53. So we definitely have to see, and we may have to seek the clarification, because the word all creditors and then the stakeholders have been used here. But then when we actually see the stakeholders, when we see section 31, that actually again we are very clear that section 31 talks about the list of stakeholders, and based on the claims, the liquidator shall prepare a list of stakeholders category wise. But all these are claims. So when we say the claims, the list of stakeholders even it doesn't have the name of shareholders, because the shareholders can also submit claim, because there is a form the shareholders can submit a claim. So all this based on the claims. No, now the only thing that we are trying to understand is, yes, for the time being, we have to understand that there may be cases where the shareholders or the operational creditors or the government departments will overpower those members of SCC who are really entitled to the proceeds under Section 53. This is something which is a scenario which is showing up. Then is the representative under subregulation 3 or 4 shall vote in proportion to the voting share. This is just like Section 6A of Section 21, I believe, from the this is the voting process. Then subregulation, the following shall be substituted. The liquidator shall convene the first meeting of the SCC within 7 days of the liquidation commencement date, and may convene other meetings if considered necessary on a request received from one or more members of the consultation committee, provided that when a request is received by the liquidator from members individually or collectively having at least 33% of the total voting right, the liquidator shall mandatorily convene the meeting. So this is, they can ask for a meeting, liquidator can call meeting. If they have to ask, they need 33% voting share, and the voting share shall be in proportion to the voting share of the stakeholders. Then in the subregulation 9, now the subregulation 9 is again, let us compare it. It says the consultation committee shall revise the liquidator by vote of not less than 60% of the 66% of the representative of the consultation committee present and voting. However, in this case, the word present and voting is replaced with shall be word voting shall be substituted. Now, what I'm trying to say, that whether they are present in the meeting or not, but they have if they are voting. Now the again question comes is that voting, if the present and voting in say voting, so that means that anyone who is not voting and not attending the meeting, then the decision can be taken with 60% of the people who are voting. So this is a change as against the COC, because in the COC meetings, we have to consider out of 100% whosoever vote, and if someone is not voting, the 66% is not achieved, and the resolution is not passed. However, in the case of SCC, in case we try to see, the present word is eliminated. However, in case somebody is not attending to the meeting but voting, then the voting would be considered as 66% of the persons voting. So that is slightly different from COC, but major difference is from the existing process where it's present and voting. So this is also significant. Then subregulation 10 in the proviso, the word mentioned in its next report, the words submit the records relating to the said decision to the adjudicating authority and to the IBBI within 5 days of the said decision and include it in the next progress report. Section 10, the advice of the consultation committee shall not be binding, provided where the liquidator takes a decision different from the advice given by the consultation, he shall record the reason for this same in writing and mention it in the next report. So instead of mentioning in the next report, there are two additional responsibilities have been casted on the liquidator. One, submit the records relating to the said decision to the adjudicating authority and to the board within 5 days. So this is an additional responsibility that in case the liquidator is not accepting the suggestions of the SCC, then it has to be submitted to adjudicating authority, IBBI, and also to be included in the next progress report. Now, after this section 10, then there is another regulation 11 has been inserted. The consultation committee, after recording the reasons, may by a majority vote of not less than 66% propose to replace the liquidator and shall file an application after obtaining the written consent of the proposed liquidator in form AA of the schedule 2 before the adjudicating authority for the replacement of the liquidator. So that means at any time the SCC can take a decision, and that will be 66% of the persons voting, and they can take a decision to replace the liquidator. Then they will file an application to adjudicating authority after taking the written consent of the new proposed liquidator for the replacement of the liquidator. Provided that where a liquidator is supposed to be replaced, he shall continue to work till his replacement is done, be suitably remunerated for work performed till his replacement. So this word will suitably be remunerated for the work performed till his replacement. And in case the fee is decided based on regulation 4, where there is no monthly fee, but it is based on the sale of the assets, and till the time of the replacement, the assets are not sold and no distribution has been made, and the liquidator is not entitled to any fee, then how the remuneration can be given. Second scenario is that in case the liquidator has sold most of the assets within the very first 6 months and he has claimed his fee and he has also taken it. So the new liquidator will be paid a fee based on the remaining work. Of course, this is the decision of the SEC and the liquidator, proposed liquidator, how they would decide. But yes, suitably remunerated, this also will add to litigation. Suitably will definitely have different meanings for different parties. Provided that where a consultation committee under Regulation 31 has been constituted before commencement of liquidation process, Second Amendment, that means 16th of September, the liquidator within 30 days from the commencement of said regulation shall reconstitute the consultation committee as required under the said regulations, and provisions provided under amended Regulation 31A shall come into effect only after such constitution. Now, what is the scenario today? The today is that the 16th of September is the date of notification. Within 30 days, we have to reconstitute the SEC in all the cases. We have to go back to our claim admittance process. We have to go back to our list of stakeholders, which is submitted to adjudicating authority. Based on that list of stakeholders, we have to constitute the SEC. And however, till that constitution is done within 30 days, if there is any decision to be taken, that will be taken by the existing SEC. Now, suppose from now till the 16th of October, if I have to take a decision, then I can reach out to the existing SEC and get that approval or get that consent or advice. However, after 16th of October, I will have to go to the newly constituted SEC based on the new regulations. This is actually the work that every liquidator will have to do: reconstitute the consultation committee, passing an office order, and by way of office order, the constitution would be done, because there is no approval required from any adjudicating authority. Therefore, it is only an office order that will be required to be done. Then next amendment is, because I think we have taken a lot of time on the stakeholders consultation committee. In the regulation 32A, the sub-regulation for the following shall be substituted. 32A, we actually will see 32A says sale as a going concern. Now, the liquidator may sell the assets of the corporate debtor under clause E of regulation 32 exclusively only at the first auction. So the feedback which was given to the IBBI was that the sale of the company as a going concern is also kind of adding to a lot of litigation, as the this kind of sales are being done even after a year of the liquidation order. Now it is said that it is only for the first auction that the liquidator may sell the under clause E, which is the sale of the company as a going concern. And further in principal regulations after regulation 32A, the following shall be inserted, namely conduct of the meeting is a separate part, but only at the first auction. So 32A, only at the first auction, regulation 4, that's something that is it, that has been added, and it has been added as a regulation.
It's actually regulation 32. 32 is up there. So 32 talks about the
32A. 32A.
E of 32.
32A. 32E, so that's a going concern. Now, corporate debtor is going concern. That's
Yes,
well
so,
taken. But
yeah, yeah,
32A, and then it is the regulation 4 shall be substituted. So what the regulation 4 was, that if the liquidator is unable to sell the copyrighted or its business A or B within 90 days, then he shall proceed to sell. So instead
Hmm.
of this, now it is said that it has to be done only at the first auction and not later on. Thereafter, the liquidator will go and sell it on piecemeal basis or on the other manners. Now, the other manners can be business as a going concern, and like clause F or clause A, B, C, D. But clause E would not be there after the first auction.
Hmm.
Yeah.
Yeah.
In principal regulations after 32A, the following shall be inserted, namely the conduct of meetings of the consultation committee, save as otherwise provided under chapter 3 of part 2 of the code and these regulations, the provisions of regulation 18 to 26 of chapter 6 and chapter 7 of CIRP regulations shall apply mutatis mutandis to meetings of the SEC under liquidation proceedings. So when we see CIRP regulations, regulation 18 to 26, regulation 18 to 26 provide how the meetings would be conducted. The CIRP regulations, in case we try to find out CIRP regulations, it will take 1 minute only, and we will the CIRP regulation up to this. Then we actually have to see the regulation 18 to so meetings of the committee, then the service of the meetings, contents of the notice, quorum of the meeting, participation to video conferencing, conduct of meeting, voting by committee, and voting by authorized representative, voting through electronic means. So these are the regulations which would apply. Mutatis mutandis means to the extent it is applicable, and these regulations would apply to the meetings of SEC, so that accordingly the notice issue, the minimum period for notice, the minimum or maximum period for voting, minimum or maximum period for minutes of meeting, all that would be applicable to the meetings of SEC. It's very clear. This regulation is not really important. Now the next amendment is asset memorandum. In regulation 34, the regulation 34 is of liquidation regulations, which is regarding the asset memorandum. This was also a feedback given that the asset memorandum is something which is taking a lot of time. So let us see what the amendment. Subregulation 1, the following shall be substituted. For the cases under regulation 1 of 35, the liquidator shall within 30 days from the liquidation commencement date prepare an asset memorandum in accordance with the this regulation based on the information memorandum prepared under section 29 with suitable modifications. Now regulation 35 and the information memorandum prepared under section 29 under section 29. No, whatever was information memorandum that was prepared during CIRP, whatever was the asset memorandum which was prepared under CIRP. Now, what this regulation says after subregulation 1, first of all, regulation, let us see what 34 says. 34, no, this is something which is CIRP. 34, on forming the liquidation state, the liquidator shall prepare an asset memorandum in accordance with this regulation within 75 days. Within 75 days, this is 34(1). And what the amendment says, that for subregulation 1, the following shall be substituted. The first of all, the time has been reduced from 75 days to 30 days. Secondly, prepare an asset memorandum in accordance with this regulation based on the information memorandum prepared under section 29 with suitable modification. So the information memorandum which is prepared under section 29 of the code, whatever information memorandum was prepared, then the asset memorandum has to be changed according to the regulation 35, and the time is only 30 days now. So this is the change, that this 75 has been reduced to 30 days. Asset memorandum which was made during CIRP, that can be adopted with some modifications under regulation 35 of liquidation process regulations with suitable modifications. Then another regulation has been inserted for cases covered under subregulation 2 of regulation 35. The liquidator shall prepare an asset memorandum in accordance with this regulation within 75 days from the liquidation commencement date. 35
so basically 35 is basically differentiating, no, between
35(1) is those cases where the valuation is intended to be adopted from the CIRP.
yeah.
And in case the valuation is not intended to be adopted from the CIRP and a fresh valuation is proposed, then it is 75 days. So regulation 35 says valuation. So in case a fresh valuation is proposed, then 75 days. In case the existing valuation and the existing information memorandum, then it can be issued within 30 days. I think it's clear.
Yeah.
And then is the subregulation 55, the following shall be substituted. Because see, subregulation 5 I was also not able to understand for all these 5 years that why this regulation 5, the asset memorandum shall not be accessible to any person during the course of liquidation unless permitted by the adjudicating authority. Now this regulation has been changed because I couldn't see any reason that why this document has to be very, very confidential. The liquidator shall share the asset memorandum with the board, means IBBI, and the members of the consultation committee having voting rights. After receiving an undertaking from each member that such member shall maintain confidentiality of the information and shall not use such information to cause an undue gain or undue loss to itself or to any other person. So that undertaking will be taken and this document will become public document.
Yeah, public document, maybe not, but yes, certainly it will become a document which is available with the creditors.
With the creditors. Now this, Ankit, you can take up this regulation.
Yeah, so proviso is being omitted. This is based on completion of liquidation where the liquidator shall liquidate the corporate debtor within a period of 1 year. This was the condition. There was a proviso that where the sale is attempted under subregulation 1 of regulation 32A, the liquidation process may take an additional period of 90 days. So 32A1 is again sale of the company as a going concern. So now this proviso has been omitted, basically making this differentiation vanish.
So the regulation 44 is very clear here, and it was saying that the completion of the liquidation, and it was basically the 30 and the additional 90 days is not allowed now.
Yeah. So where you're attempting a going concern, it is now assumed that it is part of your 1 year activity. There is no additional 90 days available for you to sell the company as a going concern.
Right.
So let's proceed. That's the only amendment here where they have removed this differentiation.
And 43 is the then I think this 43 is wrongly mentioned. It may be 44 only. Completion of the liquidation, or it should be.
It should be the same. I think it must be.
Yeah, it should be the same. It's the 44
is
a
typo. It's a typo.
The liquidator shall liquidate the corporate debtor within a period of 1 year from the liquidation commencement date, notwithstanding pending of any application for avoidance of transactions under Part 2 code. This was the amendment before.
No, this is the only the proviso is being removed. Everything else remains the same. Yeah.
Now the again 44A has been inserted. 44A, after this regulation 44A has been inserted. Treatment of avoidance of transaction. The liquidator shall, on advice of the SEC, provide in the application along with the final report filed under regulation 45 for the manner in which the proceedings in respect of avoidance transaction, if any, under chapter 3, or fraudulent or wrongful trading under chapter 6 or of part 2 of the code will be pursued after dissolution or closure of the liquidation process, and the manner in which the proceeds, if any, from such proceedings shall be distributed. So this is very clear.
The issue is that your avoidance transaction application is pending. In case it is avoided, then how does the NCLT understand that to whom those monies or those values go to, or those rights go to? So I think this is a good clarification that it is the duty of the RP that in the final report he will say that, okay, this goes to this person.
Yeah. So this amendment number 10, preservation of records, final report prior to dissolution, the following regulation shall be inserted, namely preservation of this 45A has been inserted. So 45A would be here. After the final report. The liquidator shall preserve copies of all such records which gave a complete account of the liquidation process. Without prejudice to the generality of the provisions, the liquidator shall preserve copies of the record relating to or forming the basis of. I think you can take up, Ankit.
Yeah, so basically we are relating to the or forming the basis of his appointment as liquidator, handing over. So basically all these documents are required to be preserved under this new regulation 45A, with the details of relinquishment, engagement of professionals. So the entire record of whatever decisions have been taken by the liquidator, all the reports, all the preferential transactions, then liquidator shall preserve the electronic copy of physical records and so on. So that's how the preservation is now important. Earlier there was no provision in liquidation regulations with respect to preservation of records, but now there is. With respect to the principal regulations after regulation 47 model timelines, at serial number 3 they have inserted this regulation where they have said that 31A subregulation 6 first meeting of SEC is supposed to be done within 7 days of the NCLD. So this is a change. And serial number 12, again the 75 has been changed to 30 or 75, because in case the valuation report from CRP is being used, it is 30 days, otherwise it is 75 days. So this way the process has been fastened. Then in schedule 1, after clause 1, the following para has been inserted. 1A is now says, subject to provisions of regulation 2B, the liquidator shall issue a public notice of an auction for sale under regulation 32 within 45 days from the liquidation commencement date, unless the consultation committee advises to extend the timeline. So the liquidator shall issue public notice for the next auction in case of failure of the auction within 15 days from the last failed auction, unless the consultation committee advises to deviate from the specified time period. Notwithstanding anything contained in the schedule, the liquidator shall complete an auction process within 30 days from the issue of public notice for auction. The liquidator shall provide at least 14 days from issue of public notice for submission of eligibility documents by prospective bidder. The liquidator shall provide to qualified bidder at least 7 days for inspection or due diligence. A prospective bidder in an auction process shall deposit earnest money deposit at least up to 2 days before the date of auction. So these are all changes that have been made, new regulations that have come in. Then for clause 7, this clause says, from the date to be notified through circular by board, the liquidator shall sell the assets only through an electronic auction platform enabled and paneled by the board. So they have kept this provision. We can read what the original provision used to say. We can go back to liquidation regulations and see. So original clause 7 is that the liquidator shall sell the assets through an electronic auction on an online portal, if any, designated by the board, where the interested buyers can register a bid and receive information. So now they have said that that will be only when that is based on the notification of the board. So they have withdrawn that idea. Then in the principal regulations in Schedule 2, after Form A, the following has been, so the written consent to act as a liquidator, they have inserted this new regulation, this new form. And in Schedule 2, in Form B, before the word name and signature, they have talked about in case stakeholder does not submit its claim during the liquidation process. So this way, they have inserted this provision so that the CRP regulations are also admitted. The CRP claims are also admitted. Let's proceed. So this is
I think now this is the, I think not much, but I think we can take up, Ankit, quickly you can take up the liquidation
so we will
also.
I will just wrap up quickly. Maybe we can move to the next slide. Here we have amendment number 1, where we are talking about the declaration under subregulation 1A or under section 59(3)A shall provide that the corporate persons has made provisions for preservation of its records after its dissolution. So there this clause has been added. Regulation 41, the regulation has been substituted. Preservation of records has again been basically clarified, crystallized, so that it removes any confusion on what all documents at least are required to be taken care of or preserved by the liquidator. So added
Almost
liability
similar,
there.
almost similar.
Very similar wordings, but yes, they have extended the same. So I think that's about it with respect to this regulation, that this circular that has come in on 13 September. Maybe the idea from IBBI is that any matters pending before High Court or Supreme Court with respect to their insolvency cases, wherever a liquidator or insolvency professional is having some case pending, they are now liable as per this circular to inform IBBI at an email address that they have provided in the circular with respect to how the IBBI should be informed on important cases which are going on, because it seems that a few cases that have recently come have been a surprise to IBBI, or maybe this might have been a circular which must have been in planning from earlier times, but then it has been released now, so it makes all of us think that some of these judgments need to be looked into. Also, we see that the review petition for the Vidarbha power judgment has already been filed. So that means that there might be some course correction at hand, because certain information, certain facts may not have been brought before the court by maybe even the ASG, because of lack of mandate or lack of information from the regulator.
So that's all, because this, according to my understanding, this circular is the IBBI thought that the IBBI should represent wherever some issues, legal issues are involved.
Important questions of law.
So therefore, they have given this responsibility to RPs that wherever such litigation is there, they should inform. Otherwise, the orders like Rainbow Papers and orders like Vidarbha Industries may disturb the entire code and the regulations made thereunder. So this is what all about it. And in
further 2 days ago, there are new regulations. I think we will take them up this Sunday, or plan that out like that.
Yeah,
we will take it forward then.
So I think the coming Sunday we'll talk about the further regulation which has come, and we are also expecting another regulation which might even be IPE to be considered as IP. That also we are expecting. So in case it comes, so we'll take up with this Sunday the 2 new regulations which has been notified, I think yesterday, and also maybe one more which might even be done. So thank you very much, and it is really a pleasure for all of us that you all remain connected with us. So our objective is to learn collectively. Thank you very much.
Thank you, everyone.